Our system of government uses a democratic process to elect representatives of the people. Two branches of our government use this process exclusively, the legislative and the executive. Once in office, these elected representatives fulfill obligations of their office to uphold and defend the United States Constitution by using the powers of their office to enact and enforce laws, depending on the branch. This is a mechanism of a constitutional republic, a government of laws established through a democratic process with limits placed upon government through the codified rights of the people. Our founders also knew that this type of system could devolve as a result of partisanship, and thus a third branch was formed, the judicial branch. The judicial branch was designed to be free from politics. Its responsibility was to review legislative and executive writ and its relationship to the Constitution, the Bill of Rights, and the effect these laws have on liberty of the citizens of the United States. But somehow the judicial branch has become tainted by politics, and its rulings are the evidence of this. In this episode of Office of the Patriot, I'm going to relay my findings of the growing partisanship of the state and federal courts of last resort, and what we should do to correct it. Hello, and welcome to the Office of the Patriot. In this office, I try to make sense out of the nonsense of the progressive left and rhino right. If you are a subscriber, thank you for your continued viewership. It is appreciated. If you are a returning viewer, please take a moment to hit the subscribe button so you don't miss any future presentations. And if you are a first-time visitor to my channel, well, congratulations on finding it. It's usually hidden very well by the YouTube algorithm. However, I do hope you find the content worth coming back for. My name is Myron Ibarra, and I'm your host. I really don't know how else to put this, but the United States of America is a shit show right now. You've heard me speak about our constitutional republic, the democratic process, and the social controls that we use to ensure we have an orderly society. We temper these rules with rights, like the right to say what we want publicly, the right to pray to whatever God we choose to, or to not pray at all, and the right to keep and bear arms to protect ourselves. But as of late, our government has been encroaching on not only our rights, but the processes we use to keep an orderly society. There are some things that a society has to agree upon in order to not only survive, but to thrive. One of the processes we use to that end is an impartial and unbiased judicial system. The judicial branch is tasked with a couple of responsibilities. First, it resolves conflict between parties and the law. It also determines the constitutionality of laws that are passed. So, in order for a society to believe that the judicial process is fair and unbiased when the court is fulfilling its responsibilities, they must believe that the judicial process is free of any personal bias or unethical behavior. And as of late, that belief has been wavering. And now, it seems the Colorado Supreme Court did away with the last bit of faith anyone had for a fair and impartial court of the United States. This faith was lost when the court held that Donald Trump is disqualified from holding office of the President of the United States under Section 3 of the 14th Amendment of the United States Constitution. And as a result of this finding, the court prohibited Donald Trump from being listed as a candidate on the ballot in the Republican presidential primary in Colorado. In fact, if this ruling stands, Donald Trump is prohibited from holding any office in the United States or in the United States government forever. And the only way this gets overturned is through a U.S. Supreme Court decision or a 2/3 vote in both houses of our legislature. This ruling isn't the result of a guilty finding of insurrection in court. No, it's based on an allegation of insurrection, a ruling based on half-truths, innuendo, and partisanship. Essentially, it's based on a lie. Here are a few findings the Colorado Supreme Court held. The district court did not err in concluding that the events on the U.S. Capitol or at the U.S. Capitol on January 6 constituted an insurrection. The district court did not err in concluding that President Trump engaged in that insurrection through his personal actions. and President Trump's speech inciting the crowd that breached the U.S. Capitol on January 6 was not protected by the First Amendment. To understand these findings, we have to look at what an insurrection is and what tests were employed by the court to determine if Donald Trump engaged in an insurrection. 18 U.S. Code 2383 states in part, whoever incites, sets foot on, assists, or engages in any rebellion or insurrection against the authority of the United States or gives the laws thereof or gives aid or comfort is guilty of insurrection. In the January 6th so-called insurrection, you have thousands upon thousands of Trump supporters enter the Capitol and in some cases escorted in, all with minimal resistance by Capitol Police and minimal disruption to the regular operations. No politicians were threatened, injured, or harmed, and at best, the limited and isolated lawlessness committed by some of the attendees amounted to vandalism and trespassing. If this was an insurrection, it was the most unorganized and ineffective one in the history of the United States. And this is despite what CNN, MSNBC, and every liberal news media outlet insists that January 6th was an insurrection. In Donald Trump's speech, the court found that he persisted in rejecting the election results by telling his supporters that we won in a landslide and we will never concede. He urged his supporters to confront this egregious assault on our democracy, walk down to the Capitol, and show strength, and if they did not fight like hell, they would not have a country anymore. These phrases instigated the crowd and started the infamous January 6th insurrection in the eyes of the court. In order to determine whether or not a speech, such as the one given by Trump, is protected under the First Amendment, the court should have used the Brandenburg test. The Brandenburg test was the result of the Brandenburg v. Ohio court case to determine if government could prohibit speech advocating for the use of force or a crime. The speech has to satisfy two prongs of this test. First, is the speech directed to inciting or producing imminent lawless action? And is the speech likely to incite or produce such action? Courts have already found that innuendo does not meet the standard of evidence required under Brandenburg. So, Trump stating, "Walk to the Capitol and fight like hell," clearly does not meet this threshold. In fact, in the Brandenburg v. Ohio case, Clarence Brandenburg, a KKK leader, addressed a crowd and stated, "We are not revengent or not a revengent organization, but if our president, our Congress, our Supreme Court continues to suppress the white Caucasian race, it's possible that there might have to be some revengeance taken." This speech, which is clearly designed to incite or produce lawless action, but at an unknown future date, was still considered protected speech under the First Amendment. Next, the fact that the Colorado Supreme Court could come to this finding without a conviction for inciting an insurrection is mind-boggling to me. It doesn't surprise me at all, but it is mind-boggling. It just demonstrates that the symptomatic behavior of TDS that most liberal Democrats are infected with. Rational thought goes out the window, and now, as demonstrated by the Colorado Supreme Court, so does ethical behavior as a result of manifested bias in their findings. And that's the problem. As I stated earlier in this presentation, our social controls are the bedrock of a functioning society. When faith in these systems degrades and ultimately fails, so will society. It's inevitable. There's a way back, but it will require honest oversight. And I would suggest this oversight focus on ethics and bias of the court. This oversight should come from independent state and federal ethics commissions composed of judges and laypersons with the authority to sanction judges for unethical and biased rulings. One of the tools that could be used is called a judicial performance evaluation. This is a questionnaire completed by various respondents to gather information about the perceived impartiality, bias, decision-making, and legal reasoning of the judge being surveyed. This type of oversight may have the effect of getting judges to recognize their own biases and set them aside to render a fair, impartial, and just finding, to do the job they were hired to do. If this happens, it will be a solid first step towards gaining the respect and the trust of the citizens of the United States. This concludes today's presentation of Office of the Patriot. If you enjoyed the content, please take the time to like, subscribe, and share my channel on your social media. It is appreciated. Also, please take the time to comment. Engagement is one of the metrics YouTube employs for their search algorithms. The more people that comment and like, the more my channel comes up when content like mine is searched for. And as always, have a blessed day and stay safe out there.